A federal judge just U.S. Marshals to physically breach Mar-a-Lago, not serve, papers at the gate, breach the premises, enter by force if necessary. Order, signed 9:47 this morning. This isn't a subipuena. This is a structural enforcement action. Immediate consequence. Secret Service is now in direct legal conflict with the U.S. Marshal Service over access to a sitting president's primary residence. Numbers. First forced federal entry into a presidential property in American history. But here's what they're missing. The judge's order forces the White House to decide whether to defy the Marshals by midnight tonight. That's hours from now. What the White House does next determines whether this becomes a constitutional standoff or a criminal obstruction charge. Because the Marshals have the order, the secret. Service has the guns, and Congress is watching both. Dominoes falling. Let me show you the sequence. Quick update from yesterday. Thursday, the judge issued a final compliance deadline to the Trump legal team, produced the sealed court documents by 5 p.m. Under face escalating enforcement. I said the legal team would either file a last-minute emergency stay or go silent and dare the court to act. They went silent. No filing, no appeal, no communication to the court by deadline. 19 hours later, the judge signed the martial enforcement order. That's the dare being called. What changed? The emergency stay window has now closed. The D.C. Circuit declined to intervene at 8:12 a.m. Trump's legal team filed no motion in the last 14 hours. Strategic silence that backfired. The judge's patience, publicly noted as exhausted in Thursday's order language, has converted to action. That brings us to today. The judge's move changes this from a document dispute to a physical enforcement confrontation. Here's exactly what happened. 7:14 a.m. Judge Patricia Mallett's clerk contacts the U.S. Marshal Service duty officer. 8:03 a.m. Marshal Service legal counsel confirms the court's authority to proceed. 9:47 a.m. Judge Millett signs the enforcement order. Marshals directed to proceed to Mar-a-Lago and compel access. 10:22 a.m. Order publicly docketed. Trump legal team notified simultaneously. Documented in the court docket. Case number 24 CR 000887. DDC. The sequence matters. The judge contacted Marshals before signing. That's operational coordination, not symbolic gesture. If she had signed first and notified later, it would signal a warning shot. She coordinated first, then signed. That signals she expects the order to be executed. Specific details. The order specifies any and all areas of the Mar-a-Lago premises reasonably believed to contain the described materials. It authorizes Marshals to proceed with or without cooperation of on-site security. Personnel, direct language aimed at Secret Service. A federal magistrate on standby in Palm Beach has been designated to issue contempt warrants on site if access is denied. Each detail constrains the White House's options. With or without cooperation means the White House can't simply tell Secret Service to block the door. The Marshals are authorized to treat that as obstruction. On-site contempt warrants means any individual agent, aide, or attorney who physically impedes access can be arrested immediately on the premises, leaves the White House with one viable path. Negotiate a supervised access agreement in the next few hours or watch the confrontation happen live. And a negotiated agreement requires someone with authority to make the call. And Trump's team has been silent for 14 hours. The trap. If the White House authorizes access, the documents are produced, the legal process wins, and the president's property is treated like any other. Subjects. If the White House blocks access, Marshals document obstruction, contempt warrants issue on site, and the president faces criminal obstruction proceedings before the weekend. Win-win for the court, lose-lose for the White House. Evidence of planning. The Cherby Palm Beach magistrate was placed on standby yesterday at 4:30 p.m. 90 minutes before the compliance deadline expired. The court wasn't waiting to see if the deadline was met. They were already preparing enforcement before the deadline passed. Not reactive, calculated, immediate effects. Within 2 hours of the order, 10:22 a.m., Mar-a-Lago legal. Counsel reaches out to Trump's D.C. attorneys. First internal communication in 19 hours. 10:58 a.m., Secret Service. Palm Beach field office contacts Marshal Service, Washington, headquarters. Described by sources as a coordination call. 11:34 a.m., White House press secretary issued statement. We are reviewing the order and consulting with counsel. Trump legal. Team's response filed a notice, not a motion, a notice at 11:47 a.m., stating they are assessing options. No emergency stay request. No substantive legal argument. A placeholder congressional response. Senate Judiciary. Chair issued statement at 11:02 a.m., calling the order an extraordinary but necessary escalation. House Speaker's office has not responded. Legal and institutional reaction. Former Secret Service directors issued conflicting statements. 2 supporting Marshals' authority, 1 warning of operational security risks. DOJ Civil Division confirmed it does not intend to intervene on behalf of the White House. American Bar Association released statement affirming court's legal authority to issue the order. 1 hour and 12 minutes from docketing to White House press statement. That's how fast this moved. Quote from the order. Itself, the court has reached the limit of its patience with delay tactics that appear designed not to contest legal authority, but to exhaust judicial will. Speed matters because DOJ declining to intervene is the critical signal here. If DOJ had stepped in to contest the order or seek a stay on the White House's behalf, the confrontation pauses. They didn't, which means the executive branch is not unified in opposing this. The Marshals served DOJ. DOJ stepped aside. The order proceeds. Subscribe. This is moving fast. Trump's legal team responded. 3 hours and 22 minutes after the order was docketed, here's what they did. Filed an emergency application to the U.S. Supreme Court at 1:44 p.m. seeking an administrative stay of the enforcement order. Simultaneously, issued public statement accusing Judge Millett of weaponizing the judiciary. Against a sitting president, requested that Marshal Service pause execution, pending Supreme Court response with no legal basis to compel that pause. Documented in the Supreme Court docket and Trump legal team press release. Why this matters. The Supreme Court application is the Hail Mary. It is legally available, rarely granted on this timeline, and signals the legal team has no other arrows. Their calculation, what they're trying to achieve, a 24 to 48 hour pause while the Supreme Court decides whether to take up the application, buying time past the weekend. What they're trying to prevent, the Marshals arriving at Mar-a-Lago on camera before a court intervenes. What they're willing to risk, a Supreme Court denial that closes every remaining legal avenue simultaneously. Quote from the application, the enforcement of this order would represent an unprecedented intrusion into the security and sovereignty of a sitting president's residence with no adequate legal framework to govern it. Translation, we don't have a legal argument that the judge was wrong. We're arguing this situation is too unprecedented for any court to have handled correctly, including this one. Whether it works depends on whether at least 5 Supreme Court justices agree the situation is unprecedented enough to warrant intervention, and that decision will come or not come within hours. The Cherby Supreme Court handles administrative stays on emergency timelines. By this evening, we'll know if they granted a temporary pause or let the order proceed. See the pattern forming like this? Here's why this doesn't de-escalate the mechanism. The judge issued an enforcement order that triggered Marshal Service operational activation. Trump's team filed Supreme Court application that triggered a binary outcome granted or denied. No middle path. Now both sides locked into a confrontation that resolves by tonight. If the Supreme Court denies the stay, the Marshals proceed to Mar-a-Lago this evening. Secret Service must choose in real time whether to cooperate or obstruct. That choice made on the driveway of Mar-a-Lago is either compliance or the most visible act of executive defiance in modern American history. If the Supreme Court grants a temporary stay, then enforcement pauses. But the stay requires a full briefing schedule. That means this comes back, fully briefed within days. The documents still get produced. The only question is, once the Marshals physically arrive, the confrontation is documented, visual and permanent, regardless of outcome. The image of federal marshals at Mar-a-Lago exists in the public record, whether they get in or not. That's the spiral. We're 4 steps in. Deadline missed. Enforcement ordered. Supreme Court application filed. Binary resolution tonight. Former federal judge and constitutional scholar Lawrence Tribe. There is no legal off-ramp once a court has issued a physical enforcement order and the executive has filed at the Supreme Court. One side wins tonight. Window for off-ramps. The next 2 hours. If Trump's legal team negotiates a supervised access agreement directly with the court before the Marshals depart, Millett could hold the order. After that, locked. The order executes. While the White House and the court were focused on each other, the Senate Armed Services Committee entered. Chairman Jack Reed announced an emergency classified briefing request at 12:47 p.m. Today, Reed is demanding Secret Service Director Kimberly Cheadle appear before the committee by Monday to explain the legal framework governing Secret Service conduct when federal law enforcement orders conflict with protective protocols. Why this complicates things? Reed has subpoena power over Secret Service that neither the court nor the White House fully controls. Specifically, if Secret Service acts to block Marshals today, Reed's committee becomes an immediate investigatory body into whether Secret Service was directed by the White House to obstruct federal law enforcement, which is a separate criminal question from the underlying document dispute. What they want stated goal, ensure there is a clear legal chain of command when federal agencies have conflicting orders. Quote, the American people deserve to know whether the Secret Service serves the Constitution or serves the individual it protects. Their actual interest, Reed, is establishing a congressional oversight record that survives any Supreme Court intervention, even if the Supreme Court stays the order tonight, Reed's hearing. Monday creates a public record of the White House's conduct in the hours before the stay. Evidence. The emergency briefing request was filed simultaneously with the Supreme Court application. Reed's staff was monitoring the docket in real time. Impact on the White House now managing a federal court enforcement action, a Supreme Court application, and a Senate hearing simultaneously with the Secret Service, caught in the middle of all 3. Impact on the Marshal Service. Congressional attention means every decision today is documented testimony. At Monday's hearing, neither the White House nor the court saw this coming. Reed's move converts a legal confrontation into a political and legal 3-front crisis before the weekend. This gets more complicated. Stay with me. Step back. What's actually happening? Here, the judge's strategy compel document production through force of enforcement. Exhaust every delay mechanism until physical compliance becomes the only option. Willing to sacrifice the optics of a confrontation at a presidential property, the risk of Supreme Court reversal, her own reputation for restraint, the White House's strategy delay enforcement long enough for the political landscape to shift, a new legal argument to emerge, or the Supreme Court to intervene, not win the legal argument, outlast it, willing to sacrifice legal credibility, relationship with DOJ, appearance of compliance with court orders. The Senate Strategy, establish a congressional record of executive conduct during this confrontation. Create accountability, infrastructure regardless of how the legal question resolves. Willing to sacrifice bipartisan cooperation, executive branch goodwill, risk of appearing opportunistic, where strategies conflict. The judge needs enforcement today. The White House needs delay passed tonight. The Senate benefits from the confrontation lasting long enough to hold Monday's hearing. No, compromise satisfies all three means. This resolves in a confrontation, physical, legal, or both, before the weekend. Expert analysis. Former U.S. Solicitor General Walter Dinger. The court has done everything correctly. The only remaining variable is executive will to comply. Translation, this is no longer a legal question. It is a question of whether the executive branch will obey a lawful court order. Even conservative constitutional scholar John U.A. President cannot instruct the secret. Service to obstruct a federal law, enforcement officer executing a court order. That is not a close question. When the liberal Solicitor General and the architect of executive power arguments agree on the limits of executive authority, that's the read. Fair counterargument. Trump's defenders argue that Mar-a-Lago's status as the primary residence of a sitting president creates a unique constitutional zone that has never been litigated and that no court has ever established the framework for what happens when Marshals and Secret Service conflict. That has merit as a theoretical argument, but the D.C. Circuit declined to intervene this morning, and no court has accepted that argument since the first filing 7 months ago. Both sides argue. Actions reveal the White House is not trying to win this case. They are trying to run out the clock. Every filing, every silence, we are assessing. Options is delay strategy, not legal. Strategy. This pattern isn't new. 1974 United States v. Nixon. Nixon initially refused to comply with the special prosecutor's subpoena for White House tape recordings. His legal team argued executive privilege created an absolute shield over presidential communications. The Supreme Court ruled 80 that executive privilege is not absolute. Nixon complied within days. Result? Documents produced. Presidency ended 16 days later. Timeline 6 months from initial subpoena to Supreme Court ruling to compliance. Key difference, then Nixon was not physically present at the location being searched. The tapes were in the White House, not at a private residence, actively protected by armed secret service detail. But the dynamic same, executive claims of privilege, judicial orders compelling production, Supreme Court as final arbiter, delay as primary, strategy, former Watergate special prosecutors, office attorney Jill Wine-Banks. Every president who has tried to use the courts to delay compliance with judicial orders has eventually complied. The cherry question is always the cost of the delay. We are at the Supreme Court as final arbiter stage. Now, if history repeats, Trump complies within 48 to 72 hours of a Supreme Court denial. Documents are produced. Enforcement order becomes historical footnote. If it breaks, the White House would need to direct Secret Service to physically obstruct Marshals, an act of executive defiance that has no precedent and no legal defense. Like if you're following this thread, why this matters. If you've ever assumed court orders are self-enforcing, they are not. And what happens today establishes whether they can be. A federal judge issues an order. The losing party ignores it. The judge sends marshals. The party controls a location protected by armed federal agents loyal to the executive. What happens? Until today, that scenario was theoretical. After today, it has a precedent. Whichever way it resolves. If marshals succeed, court orders hold, even against executive resistance. Every future president knows enforcement is real. If marshals are blocked, every future litigant against the executive now knows the court's enforcement mechanism has a ceiling. The cherry precedent, the boundary between judicial enforcement authority and executive protective authority has been drawn in practice on the ground today. Bottom line, if you believe in a government where courts can compel compliance from anyone, including the most powerful person in the country, today is the test of whether that belief is still grounded in reality. This is not about documents. Documents are the triggering event. What's being decided is whether any court in America has enforceable authority over a sitting president who decides not to comply. The founders wrote that no man is above the law. Today, federal marshals are being sent to test whether that sentence is still operational. If you live in a constitutional republic, this connects. What happens next? Today, by approximately 5 p.m., Supreme Court must decide whether to grant a temporary administrative stay of the enforcement order or deny it and let the marshals proceed. 3 possible outcomes. 1, Supreme Court denies the stay. Marshals proceed to Mar-a-Lago this evening. Secret Service must cooperate or obstruct in real time. If they cooperate, documents are accessed tonight. If they obstruct, contempt, warrants issue on site and individuals are arrested.